Hello, this is Bradley Bailyn. Today we're going to be talking about the jurisdiction clause in commercial agreements and to what extent it matters. Hint, it matters a lot. I like to call this episode, It's All Fun and Games Until Somebody Loses the Case, because it's that important, and I'm going to tell you why. The first thing you need to understand is that judges and juries are human beings. Judges and juries are explicitly biased. Judges and juries are implicitly biased. Judges and juries are directly influenced by the law of the jurisdiction that they're in, as well as the culture, which is the context in which they interpret the law. So, how did this come up? I had a client who came in today who is manufacturing an environmentally friendly product. For people who are into the whole green movement, every ingredient in the product makes a tremendous difference. It's a big competitive advantage to be 100% organic, 100% environmentally friendly, and so on. So if even 2% of the product is not biodegradable, that would render the product no longer commercially feasible and kill the whole marketing plan. Now, we are making a contract with a manufacturer. If the manufacturer puts in the wrong ingredient and we need to take this thing to court, what do you think is going to happen? The answer should be, it depends. If the judge is in San Francisco, the judge is probably going to say, oh my goodness, that could kill the coral reefs. Please don't manufacture any more of cosmetics that are not biodegradable. If the same case has Texas jurisdiction, which is where they wanted it, the judge is going to say, it's a perfectly good product. It's a small error. It's not a problem at all. Now, granted, we can guard for this particular thing in the contract itself, but there's going to be 100 other issues that could come up that neither me nor anyone else in the world can necessarily anticipate, which is why it's very important that the case is being heard in a jurisdiction and by a judge who's going to be coming from the same place that you are coming from. So that's the first issue. That's one of the reasons why so many corporations are headquartered in Delaware or in New York, because when you're going to engage in sophisticated legal procedures, judges in Delaware and New York are going to understand what you're trying to do and why you're trying to do it. And there's case law regarding it, and it's highly organized, and it's likely to go well. If you need to bring a case about something similar in a less sophisticated jurisdiction, you could end up with a conclusion which is more or less unpredictable and totally depending on the judge. And that's not a good thing when you're making decisions worth millions of dollars or billions of dollars. So, okay. So one other thing to consider in the same vein is how do judges get their position? Judges are either appointed or elected. Regardless, you have to be a Democrat or a Republican for that. You go to the political party boss and you tell them, I want to run for judge on the Democratic ticket, or I want to run for judge on the Republican ticket, or you get appointed by the governor or the president of the United States, and they are typically going to appoint people of their same political party. So if you have a product which may be affected by a judge's political bent, then you really want to make sure that you've got the right jurisdiction for that kind of thing. Secondly, you also have to just pay attention to what the law is and what you are most likely to get sued for. Some states and some counties have very different laws regulating the same kind of product than others do. And this even outweighs whatever political bias the judge or the jury might have. If you've just got a much shorter statute of limitations in one place than another, or there's some kind of a procedural hurdle that the other guy is never going to know about unless they have really done their homework ahead of time, then you definitely want to go where you're going to get the legal advantage. A legal advantage is almost always better than a political advantage. And lastly, there's just the matter of convenience. Some courts will allow telephonic appearances. Other courts will not allow for telephonic appearances. So also some courts will allow a business to be represented by an officer. Some courts will require a business to be represented by an attorney. All else being equal, if you're in New York and the other person is in California, you'd like jurisdiction to be in New York. You'd like to be suing in the lowest court possible, where it's going to be the greatest hardship for them to come and fight you. And you're much more likely to have a positive resolution than if you have to go to their hometown. I once saw a jurisdiction clause where jurisdiction was in a county with very few people in upstate New York. And I was like, you gotta be kidding me. It's almost for certain that this important manufacturer knows the judge very well. Good luck bringing a case in that county and thinking that you're going to have any success there. We said, no way, it has to be in New York City. It's not even logical to be having a case being held at your neighbor's house or wherever it is that, whatever kind of kangaroo court might exist where that company is located. Let's see if we have anything else to cover here. So the last thing I just wanted to mention is arbitration. Arbitration is also a possibility. Sometimes you're able to reach a compromise and say, okay, well, jurisdiction is going to lie wherever the defendant is. But again, that depends on what is the likelihood that you're going to be the defendant versus the likelihood that you're going to be the plaintiff. So the trick with arbitration is this: arbitration is very expensive to file. And it's also a simplified and speedier process. So if the amount of money is relatively small and you're the one who's more likely to be sued, then you may want arbitration, because people are going to see that for a commercial arbitration, it's maybe $2,000, and usually the other side defaults. And by the time you pay all the fees yourself to file the arbitration, you get the arbitral award, then you have the award confirmed by the court, then you go to whatever jurisdiction the defendant is in and hire a lawyer to enforce the judgment. The whole thing becomes not even worth it. So also, if there's trade secrets you need to protect, then you need an arbitration agreement. Otherwise, unless you're a big company, an arbitration agreement is probably not the best idea. Big companies like arbitration agreements because a lot of consumer protections that are available in court are just simply not going to be available under an arbitration agreement. So arbitration is extremely common with cell phone companies and utilities and other large companies that deal with consumers like that. And there's even a bunch of laws now being proposed around the country that make it illegal to require arbitration in employment matters and other matters where a big person is bullying a small person. If you'd like to talk more about jurisdiction, please feel free to drop me a line. My phone number is 646-326-9971, or you can email me, brad@bailynlaw.com. That's brad@BAILYN law.com. If you're still here with me, thank you for your patience. Have a great day.